I've gotten the go-ahead from my marketing team. I think we can start the session off. Hopefully we'll have more members joining, but it seems we'll have a nice intimate session today. Everybody, thank you so much for joining us for this conversation. My name is Claude de Villiers. I'm the head of solutions here at LexisNexis. I myself am an admitted attorney, although I haven't been in practice for a number of years. I have a master's degree in banking law, spent some time in compliance, and legal counsel in the banking industry before moving over to technology sales and sort of finding my way back to where I am now. I'm joined by my co-panelists, and thank you very much for joining us. First of all, Mokone Finger, who's an admitted attorney as well, with a LLB degree from the University of Free State, a master's from the University of Witwatersrand. Mokone is an admitted attorney. He's spent 7 years in practice in various parts of litigation, as well as commercial work. Currently, he's the group legal manager for the Clinics Health Group, and we're very privileged to have him join our conversation today. Nomsa Ntibande is also an admitted attorney. She has her LLB from the University of Northwest. She also spent 7 years in practice here in Centurion, and is currently, I'm proud to say, a client success manager here at LexisNexis, dealing primarily with our new clients on our L Plus AI platform. And we're very privileged to have you as well, Nomsa. Welcome, Mokone. Welcome, Nomsa.
Thanks, George.
And I think before we kick off, maybe I'll just start us off with a little bit of background on our topic today and the structure of our conversation. As the title, says, of the webinar says, the transgression of the billable hour is a really big talking point, not only in the legal profession, but globally in the workforce. With the rise of advanced automation and of AI and the automation of big repetitive tasks, the question becomes whether billing for human hours is still a viable path going forward. And certainly the billable hours become synonymous with the legal profession. But I think it's important for us to start the conversation by saying the legal profession doesn't begin and end with the billable hour. In fact, the billable hour is a fairly recent development within the legal fraternity. Most of us in this room will have practiced our entire careers billing via the billable hour. But it is important to note that until, the billable hour became the norm in the legal industry following the Great Depression and following the intervention of management consulting companies in large law firms in the US, and then it all filtering down into most common law jurisdictions, the legal profession operated on a locatio condictio operum operanum contract, similar to a lot of professionals like doctors, dentists, the like, who effectively charged for work as is, and there was a lot more trust placed in the legal practitioner. And so I don't think that it would be a death knell at all for us as a profession to go back to that model or to a different model. And I think that's the purpose of today's conversation, is really, first of all, to go, why would the billable hour be in jeopardy of changing? And secondly, where do we go to from here as a legal fraternity? And is that bad or is that good? So the agenda will be fairly flexible and informal. We do have a formal Q&A session amongst the panelists, but very quickly that will devolve into a conversation. And I'd like to encourage all of the attendees to please be actively involved. If there's something that springs to mind, I'll have a look at the chat function to make sure that your voices are being heard, and that myself and Nomsa and Mokone do get to those. I want to start off with a question for you, Nomsa. 1 second, I've got my questions panel mixed up. I've had this wonderful LLM, design some questions for me, and I think I'm giving away some of the reason why the billable hour's gone away, but now I've put it on the wrong screen, so that's human error.
Yeah.
Nomsa, can you walk us through the current billing models in legal practice in South Africa and explain what is working well and what do you think needs rethinking?
Absolutely. Good afternoon, everyone. Thank you so much for the warm welcome. Before I get started on answering the question, I just want to say, with this conversation, I like to speak about evolution. And this is exactly that. Law, AI, and the likes of our billable hours. So I want to say this quite quickly to everybody and say growth no longer waits for gray hairs. In this age of algorithms, evolution begins with curiosity. And one must be curious, especially about regarding the question that Claude here posed to us. It's important to note that in South Africa, billable hours are very dominant because they are enshrined in the Legal Practice Act, right? So what we do know is that attorneys charge on client and attorney scale, but we also have what we call a contingency fee. And this is part of how attorneys bill, if I may put it that way. And this is a no fee or no win, no fee basis. And I hope I'm taking you guys on the right path here. You're following on what I'm saying. It's entrenched largely, as I said, in the Legal Practice Act. It provides guidelines. The Legal Practice Act provides guidelines. And what this actually does is it provides ease of tracking, right? So attorneys are able to track on what am I doing? What am I billing on? Am I billing on valuable time or valuable info versus admin, if I may put it also that way. Claude, I hope I gave you an answer and I've not left out any aspect of the question you
Very
asked.
good answer, Nomsa, and thank you so much for bringing that up. I think I touched on, the first part of the alternative to the billing hour, which is effectively charging for a piece of work. You touched upon a very important point there with regards to the contingency fee agreement, which is something already entrenched in our legal, fraternity. Well, Connie, I'm going to ask you about a third entrenched model, and that's the retainer model, because you are in-house legal at the moment. What do you think the pros and the cons are of that? And is that something perhaps with productivity and the nature of productivity changing, is that a model that, going forward will be more, used by the legal fraternity?
Thank you, Claude, and good afternoon to your audience. I think before I answer your question on the retainer agreements, perhaps let's take a step back to appreciate that the billable hour has always been central to a revenue generating component of law firms' economy. And certainly this is what dictates whether a law firm is going to be sustainable in the future or even presently by offering services to various clients. More recently, we found that the emergence of legal spend, which is driven by clients, is certainly something that introduces analytics and tools to determine whether a lawyer is going to do work and that work gets billed for what is efficiency or efficient. I think this tool introduces and comes to the question that you've asked about retainers, because if a client is able to control tasks and the hours that are billed by a legal professional, certainly there needs to be a measure of tool whether that particular work speaks to the invoice that is then given to the client. And I want to segue to the challenges that are experienced by the billable hour model, which forces us to start looking at alternative fee arrangements such as a retainer or contingency fees that need to be modeled by technology. Law firms rely heavily on manual processes. And I think people in the audience can appreciate that, law is a slow profession to advance into technology. And a lot of the routine tasks that ought to be done by technology and artificial intelligence are still being done by manual processes and predominantly done by a lot of the junior lawyers. Another criticism that we face is that clients have previously criticized that the billable hour does not have transparency and it lacks unpredictability. It lacks predictability. So when you slap an invoice to a client, one obviously would then ask whether that particular work speaks to the invoice that is then given to the client. But what we are then seeing in the industry as a client is that I need to then start reformulating what retainer agreements I have with external counsel. Do these need to be infused with technology to ensure that my needs as a client are then met? I think then the question is, or rather the proposition is that law firms need to start adopting technologies that embrace alternative technology or arrangements that are going to adopt practices that ensure efficiency is maintained when we explore fee arrangements.
Absolutely. And Mokone, I'm gonna keep you honest there. You're quite right in saying, technology is changing the landscape. And I think that's why we're having this conversation. I think when the billable hours started in the 50s and the 60s, it was revolutionary because it gave certainty that a lot of clients were demanding in the industry to say, what am I really paying for? And it coincided with the rise of the timesheet in the general working population. You clock in, you clock out, and the monetization of human effort per hour, and we've all sort of clung to it. But I think the cracks to this sort of model already started showing in the 2000s with the rise of technology. The fact that you now, instead of needing an article clerk to run to the court, you often can mail the documents to somebody there. These are small examples, but you've certainly touched on some of the bigger examples, like, for instance, a lot of the manual tasks that now can and should be done by technology, and how the billable hours sort of become a victim of its own success. Because the problem now becomes, if you're not spending 7 or 8 hours on a matter or on a certain task, how are you able to bill a client the same value? And I think it circles back to where we were originally, with regards to other professions. If I'm paying a dentist for a root canal that they have to do to me, whether they take 3 or 4 hours is of no concern to me. It's whether they are performing the service correctly. And my personal opinion, and I'd love to get your guys' input, is that we are sort of moving more towards that sort of model, in terms of paying for a piece of work or paying for an outcome, as opposed to paying for hours, which is it's very, very difficult to quantify these days. We've already discussed the two different models that are alternatives at the moment, but I'd love to hear your opinion, Mokone, and your opinion, Nomsa. And I think you can start with you, Mokone, and then move on to Nomsa, around whether that aligns with client expectations. Clients in this case would, I assume, include you, Mokone, because I'm sure you utilize a lot of external counsel.
Thanks, Claude. I think given the rigidity that we are seeing in the billable hour, I think given the challenges that we've mentioned using the billable hour framework, is that there has been certainly a move towards some type of alternative fee arrangements, even though they are not regularized at the moment, and obviously there are no policies. I think Nomsa had mentioned in the introductory response that we have the billable hour philosophy, which is entrenched through practice, and then we have the statutory process, which is the Contingency Fee Act, which speaks to the contingency fee arrangements. But I think aside from that, there are also some type of alternatives that we can start exploring. Certainly fixed fees, contingency fees, value-based pricing, which may offer efficiencies and transparency, given the challenges that we mentioned. And that may significantly foster stronger relationships between us as clients and law firms. I think the use of technology certainly forces us to start relooking how we are billing, or how law firms are billing their clients. The fortunate or unfortunate rapid rise in technological advancements is forcing a lot of businesses to start relooking their pricing strategies that are going to reshape, the business model. Generative AI, which is a type of artificial intelligence, is certainly disrupting the billable hour philosophy. I don't think we are going to do away with it. Later on, maybe we'll touch on hybrid models and how hybrid models have been embraced by consulting firms. You mentioned earlier in the introduction that billable hours, as we've seen, come from the US, and consulting firms and auditing firms has made their way to South Africa. And I think that is no different from the new hybrid models that are coming into the forum.
Very, very good point. I actually love the way that you frame that there, that, probably within the next 10 to 15 years, what we will see is the emergence of hybrid models as opposed to a direct shift from the billable hour to something else.
Yeah.
Nomsa, what's your opinion?
Thanks. I think it's important to note that, like I said, evolution, ever changing, right? We bill by the hour. If I'm consulting and you are in front of me and we are speaking a specific language, I'm billing you for that time. But now comes, like Mogone said, generative AI. What I was able to do in 6 hours, I'm now able to do in 5, right? What is the conversation then between myself and the customer or the client? Where is the transparency? Because prior to that, what I was doing was, hey, let's consult. I'll give you an invoice after the matter has been concluded. Now the conversation is, well, look, what I can do for you is X, Y, and Z because I'm spending less time on, say, research. And that's why we have your generative AI or AI in general. It makes things easier, quicker, faster, accessible to information. So you're not sitting 6 hours doing research. You're not sitting 6 hours drafting a contract. If you, and I'll make this analogy quickly or an example, you're an attorney drafting a contract, 6 hours, charging 2.5 per hour for that contract, right? And you're billing per hour. So I've concluded your drafting your contract in 2 days. Calculate that, that's your fee, standard. But now I've got this platform that can do that for me in less than 6 hours. So now my transparency or the likes of transparency needs to come in conversation with my client saying, hey, well, I'm no longer charging you by the hour. I'm charging you for value of the product. And this is what you've mentioned in your introduction. I'm bringing quality. I'm no longer charging for quantity. It's quality that I'm giving you. So this is where we are becoming transparent. 1, 2, we have the likes of our legislation that is giving us guidelines on how to charge. We're not overcharging or undercharging. We're providing a service. So yes, billable hour, we will do away with it. We will come into the hybrid part of things. Are we looking at billing by the hour? Are we looking at a fixed fee? Are we looking at a subscription? Are we looking at a premium? Attorneys or the legal fraternity needs to come in. And not only the legal fraternity, I mean, other organizations come in and look at your structure, analyze it, have the likes of your softwares that are able to analyze and see, this is the service I can provide this set of clients, and this is how I'm going to do my metrics for these guys, and this is how I'm going to have my conversation with X, Y, and Z. So, yeah, billable, we're slowly moving away from the billable hour. We're going into this hybrid. I hope you answered.
I love what you said there, Nomsa, about relationships, right? I think a lot of the chase around productivity and a lot of the questions around how technology will change, evolve, or do away with certain jobs lose sight of the fact that at the core of most client relationships or any business relationship is a relationship with a human being. And I think that the client is a very important stakeholder in this. Why I also think the client's a really important stakeholder is that ultimately the changes to these models will be market driven, right?
Correct.
We're going to start seeing, as you both mentioned, improvements in productivity, great improvements in productivity brought on by a lot of this technology. And rightfully or wrongfully, us here at LexisNexis, we're part of that solution, part of the problem, if you could put it like that. But that will start happening. And what I think you're going to start seeing is that attorneys who do cling to the billable hour model will increasingly be outpriced by competitors using a more competitive model that's more appetizing to a client. And so that's a really good way of looking at it. And then I'd like to ask both of you, are there innovative pricing frameworks from other industries that could be adopted to revolutionize the way South African law firms approach legal fees? Let's start with you this time, Nomsa.
No problem. Claude, I want to go back quickly to what I said with regards to the hybrid
Please.
model. I want to tap quickly into not fixed price, but subscription based. So you have other consulting agencies or organizations that are charging a subscription fee for a legal service or for a particular service. And if you're paying a subscription fee, you are put under a different or a certain particular tier, right? You're paying for X amount and you're receiving this service. So depending on the tier that an organization will put you under will determine what kind of service you're getting. So yes, if you are looking, we'll go back to Magone and say the retainer fee. If I am going to sign that agreement with, say, a client, I'm going to be providing you with the service XYZ, and you're going to be paying me premiums on a monthly basis up until a particular time. And then we want to go into your fixed fee, if I may just tap into that quickly. We have seen that amongst the legal spectrum, I'll say. And mostly, I would say in the conveyancing part of things, there's a fixed fee there. So what you're doing there is not saying, look, I'm not being transparent with you. You have a transaction. You'll pay this on conclusion of the transaction. No. What you have there is, this is how much you're registering a property for. This is how much I'm expecting to be paid. So that's a fixed a fee that we're looking at. But in terms of litigation, I mean, attorneys can, and I believe we are going towards that. Attorneys can think of subscription fees. Take your medical aids and your healthcare. You have a medical aid and you're paying a premium on a monthly basis. And what are you receiving? Healthcare. You can go to the GP, you can go to the hospital, and you are also under a certain plan. So attorneys can look into that. Lawyers can look into that. We can look into which product, which service are we providing, which criteria are you falling under? Are you only receiving labor law advice? Are you receiving criminal law? Are you receiving templates or documents?
Yeah, Nomsa,
Really interesting stuff. Well, just before we move over to you, Nomsa, I just want to acknowledge two of the things that you mentioned there that were super interesting, and just point out one of the things that we haven't mentioned. You're quite right in saying that in the conveyancing space, that there is already a fixed fee there. Up front, if your property is worth a certain amount, that's what you're paying upon registration. And I think that's true of deceased estates as well. From the get-go, there is an allowable amount that the legal practitioner can charge for the administration of a deceased estate. And I almost think that we'll see that model expanding. Obviously, that model is not without its own issues, especially towards the consumer. But I think we can discuss that on another forum. And then secondly, the model that you mentioned with regards to the subscription model, I actually think we've already started seeing that with some organizations like your Clientele or your Legal Hero, charging that, especially for basic legal services, basic legal advice, and sort of filling in that gap by providing these sort of entry-level clients with certainty, but also with a quality basic legal advice to start off with. So very interesting you bring that up. Mokone, your thoughts?
Thank you, Claude. And Nomsa mentioned quite a good point when she was talking about hybrid models. And I think these, if they align with artificial intelligence, one would be able to measure outcome, value, and results of various cases. Perhaps let's touch on the advantages of a hybrid model that we've seen from other industries, such as the auditing firms, consulting firms, because these are industries that have started implementing hybrid models. I mean, looking at speed and consistency in the delivery of services is certainly one of the advantages when one adopts a hybrid model into their pricing framework. And we've seen, again, scalable growth. When you want to introduce new revenue, again, it's going to help you to adopt technology. Otherwise, if you have been spending a lot of your time doing a lot of the manual work, you can now dedicate some of that work to creatively coming up with new revenue. Then there's embedding, proprietary platforms that craft work that you can sell to various clients. We've seen, the rise in contracts that you can buy from a store, and you just input various, details that personalize that particular contract. perhaps it's time for law firms to look at other products that they can develop from using technology and actually be able to sell onward to clients. Again, it's giving clients some type of power in managing their own expectations. Certainly a subscription service for other types of legal work will certainly work.
That's so true. And I love the fact that you pointed out there. I think often we view a lot of these developments as negative, the billable hours going away, how am I going to bill for my time, etc. But it's important to note that as a profession, the legal profession really is fairly innovative. In as much as the saying goes that the law is an ass, I do think individual legal practitioners are more than capable of adapting technologies and making sure their practices are at the cutting edge, providing value to clients, and ultimately generating revenue for them and for their practices as well. And it's very interesting what you brought up there about how we can learn from other industries and the sort of hybrid model that they are providing. I'd like to touch upon another point. We've all mentioned it, by the way, on technology, right? Because a lot of the reason that we're having this conversation is the fact that there has been a large change in technology, and especially technology influencing the productivity of white-collar work within the last 20 to 30 years. It's why the billable hours slowly but certainly sort of cracked. But I think we're now at the point with LLMs and with advanced AI, where really that it becomes a very particular question. But I'd like to start with you this time, Okone. In what ways are emerging technologies influencing the traditional billable hour model? And again, we've touched upon some of these already, but I'd like us to, just for the sake of the audience, to go into the detail around individual places where the technologies change the billable hours. So can you walk us, can you take us through how these emerging technologies are changing the billable hour, on a bit more of a granular basis? I think following this, I'm going to take everyone through our AI platform, just as an illustration for me on how these individual nuances come together, and then we can continue the discussion after that. But Okone, I think over to you first.
Thanks, Claude. I think we've seen a slow emergence of certain technological platforms amongst law firms. I think the last couple of years, we've seen task automation. Work that would otherwise have been done manually has now formed part of a certain workflow. So a document review and legal research, I mean, the likes of the platforms like LexisNexis, certainly where you input a search, you'll be able to find results quite quickly by refining your search. Then there's document management. I think everyone on the call certainly has some kind of a cloud system, be it a Gmail, an iCloud system, which helps with storage, review, and retrieval of information within seconds. This is no novel to other industries such as law as well. In law, where you are able to input and paginate certain documents, it can do it in seconds as well. This is where we've seen technology certainly assisting us with speed and consistency and accuracy of document reviews. Then there's big data. It sounds like such a big term, but really big data and looking at analytics is certainly looking at outcomes and results. Am I able to predict what's going to happen in a case based on other cases that I've dealt with? I mean, lawyers already, I'm sure they're having the lights go off. They're thinking precedents. Certainly, if technology can offer you precedents at a touch of a button, I think certainly this is something that we should embrace. Of course, there are various areas of law that you still have to go and look at case law. But I think in areas that you can certainly input a search and be able to find information and big data and analytics, I think it's something that can be embraced. That will certainly also reduce your client's cost. When one client receives a big bill for researching, it can be frowned upon if you wanted the lawyer to focus on other areas of your matter. Certainly technology, this is where we've seen it emerge and help reduce costs but also meet client expectations.
Connie, I'm just before we move over to you, Norm. So I'm gonna pose a bit of a cheeky question here, but obviously the reduction of costs by necessity, by the way of the model, means a reduction of fees for the lawyer. Now, I mean, I think everybody in this room wants to try and avoid that. How would attorneys go about still giving the client additional value, still being able to fee the same for the work that they've provided, but at the same time spend a lot less time on it? Because as you said right now, you know, a lot of emergent technologies at the moment mean that certain tasks that used to take 4 or 5 hours can now be done in a half an hour. I think that the ideal outcome is for the client to have a superior service from the legal practitioner, but not diminish the value of the work. What would your answer be to that?
I think given the competitive pressures of changing economy are forcing lawyers not to only deal with one area of law. If you used to be a family lawyer, perhaps it's time to look at other streams of income that are creatively going to ensure profitability of your business. And I think technology, I mean, given how quick it is to search for things on the internet, and again, we won't go into the accuracy of what you can find on Mr. Google, but it's important that one expands their business in order to ensure that there's new income streams that are being generated through use of technology. Again, when one finds that they were dealing with one area of a matter, they can creatively use the time left, let's say on the money. If you're using a retainer schedule or a contingency, you dedicate that time to other areas of your client's business. If your client is a mining company, you start looking at what are areas of law that you can assist your client. So perhaps again, it's remodeling how you offer your business or your services to your client's operations. I hope that answers the question, Claude.
Answered it very well, thank you. Norm, so over to you.
Man, I loved what you said there, Mogone. I loved you answered that so well. I think there's no competing with that. Listen, so just to answer on emerging technologies, and I'm also going to touch on your response there, Mogone, because it was quite interesting. I think it deserves just my 2 cents on it. Emerging technologies and how they're changing the legal spectrum. I'll say, or perhaps reducing time spent on certain tasks. You mentioned document automation. Yes, absolutely. So instead of spending time drafting an affidavit or drafting the likes of your heads of argument or having a template that you copy and paste, you have a document that you can autofill. It's already done for you. You just complete the name, facts if you must. And then you've got your research, like I said. If you're not spending time pulling books out of a library, 10 books out of a library, opening, looking through indexes, trying to find the relevant topic, now you've got AI that can read the book for you. You can pull it from the shelf on your screen and ask questions based on that. It's like a conversation, except here we are using sources that are reliable. And it is the responsibility of the attorney to ensure that they are using sources that are closed, sources that are not exposed to Google, like you said. It is very important to note the evolution we are stepping into. It is important to note what it brings to our profession, but also not to take away our responsibility or the responsibility of attorneys. Because if you've got something, an AI-assisted paper, one, it's driving efficiency, and yes, it's reducing costs. So instead of spending time on one task, like I said, for 6 hours, and this is me now putting my 2 cents into your last a statement that you made, your answer, you are spending time on other areas. You know, you are opening yourself up to not only family law, but labor law and the likes thereof. It is also important as a director and attorney to have the knowledge in other expertise, if I may put it that way. You don't only want to go in and say, well, instead of spending 6 hours doing my research, I've spent 10 minutes or an hour, and now I have the spare time doing absolutely nothing. be customer centric. Go out, know your customers. Know that in a day you used to spend 6 hours on this. Now you're spending 3 hours attending to 3 files, providing feedback to 3 clients. You're making money. You're pulling the customers in. So, and you're doing everything in a fraction of time. You're no longer spending so much time on those activities that you were doing. And sorry, not admin. But the most important part of your work, you're getting done. You're bringing customers in. You're bringing clients in. You're bringing the work in. And you're not only focusing on one area. So AI or AI assisted platforms or softwares can honestly assist you do much more than what you do on a daily basis, and that is manually doing those things. So I want to make a quick example. Claude said he'll give a quick demo. Drafting a heads of argument is not as simple as reading a founding affidavit and saying, oh, or in answering or replying or the likes of whatever documents go into drafting a heads of argument. You don't read it and then, oh, it just pops into your head. We have systems where you can pop those in. And I'm not talking, I don't want to mention the names, but I'm not talking about Google softwares or platforms, but we have trusted softwares where you can upload those documents and say, look, draft me a heads of argument, comprehensive you will get from that platform, but it is still your duty to do your due diligence. Read up on it. You don't want to go up to Judge Masipa and she's reading your heads of argument and she says, gee, this doesn't sound like Mogoni. You understand? Put a touch of your personality and your character into it. You know how you draft your documents. You don't want to sound singular either, because that's what AI does, unfortunately. It provides us with something that everybody has access to, but you don't want to sound the same. So you still have your character. You're not removing your hard-earned work or your labor from the document. All you're doing is everything at a fraction of time, and you're just reviewing your document.
Thank you so much, Norm. So that makes perfect sense. And I loved some of what you were saying, and I'm going to touch upon that now. Hindefo posted to the host and panelists, less time spent means more clients to service if more clients are available. And that's absolutely true. I'd like to add to that and say less time spent also means more time spent on strategy, value, quality of the work, which ultimately is what our clients want from us, is the outcome, the quality that our experience, that our training provides, as opposed to just the slogging hours. I shudder to think that our clients really care how long it takes us to draft something. It's more that they want a certain outcome. And so, Hein, thank you so much for that. Mokona, you touched upon this, and Nomsa, you definitely did touch upon it. And before I move over to the demo, I think we need to address this. Is, as much as I think we all agree that the world is changing. A lot of tasks have been automated. There's all sorts of platforms out there to be able to give attorneys and advocates and basically anybody in the legal or compliance field access to these tools that give you amazing boosts in productivity. At the same time, there's a responsibility. And we've seen that with the Mabunda cases, with the Northbound case, all of the cases globally happening as well, not just with regards to hallucinations, but also with regards to the exposing of privileged information onto an open source LLM. The first one obviously is the hallucinations part, and I think I'll address that as I go through the demo. But with regards to the POPIA non-compliance, POPIA GDPR non-compliance / non-compliance with the ethical requirements of the Bar Association, the Law Society, the LPC. That's a very important thing to consider. I think we've seen massive cases globally now being brought against OpenAI, particularly around the use of client information, privileged and or proprietary information to train its models. And I think it's important for everybody in the room to note, if you're using ChatGPT or a similar open source LLM to do your research, there's two fundamental problems that you sit with, and there are ways to address them. But the first one is, what you put in there is being used to train the model. So if the information that you're putting in there is proprietary, or in most lawyers' cases, privileged information, you need to know that at a fundamental level, you may be non-compliant with your ethical requirements as an attorney. And secondly, that the quality of that answer needs to be questioned. And certainly that's where, Norm, so you touched upon this, the value of being a trained attorney, being a trained advocate, somebody with an eye for detail, somebody who is effectively trained to provide this answer themselves, comes in to be able to verify the facts provided by the LLM, add reasoning, add nuance, take away non-applicable law, non-applicable precedent, like you were saying, Mokone, and really impose your own voice and your own judgment on what's being given by the LLM. But so that's a very important question. Both of you have brought up. I'd like to share, just a quick intro onto our system that we launched earlier this year, Lexis AI. Now, obviously, I'm being biased when I share this, but obviously, it does serve to illustrate a lot of the questions we brought up today around productivity, around the change in how we are productive as attorneys. First of all, I mean, we have 4 basic functions in our AI offering, but I'd like to start off with, what we started off with was how the practice of an attorney and the practice of an advocate's fundamentally changed. I always like to say that it's a pyramid. And you start off with where the legal profession was for thousands of years, where you have legal practitioners reading books and needing to buy books, going to libraries, doing their research, drafting their own heads of arguments by hand, and giving this value to the client. And then you have the second step of this evolution, which sort of happens in the 60s and 70s with the digitization of legal content, where you could buy floppy disks or you could buy digital content containing legislation, containing precedent, and indeed the rise of personal computers, where you don't have to type things by hand. This already changes fundamentally the productivity of the individual legal practitioner, and obviously cuts a lot of time in doing menial tasks. The third step, and again, most of the people in this room are privileged to have been involved in probably 3 out of these 4 steps, and seeing that development, especially if you've been in practice longer than 30 years. The third step was the rise of the internet, where information became digitized. So this digitized legal content that organizations like LexisNexis or the JUTA offered is now available on a searchable platform. It's updated daily. And so it's even more convenient. And then the fourth step is the one that we're currently in, is the rise of AI, and the use of AI agents to be able to really retrieve this information very quickly and make use, like you were saying, Mokone, of that large data. Now, a few things to note about Lexis AI and the model that it's trained on. First of all, it's a closed loop LLM, which means that effectively any answer or any reply that you get from our LLM will come only from our system. We do not train our AI on any of the inputs from our users, and so what you put in here remains privileged. Our own technical team is not even able to access your inputs. And secondly, the model is only trained on our proprietary database. So effectively, if you get an answer from our model, it's from Lexis Plus, the legal library, the database that we have. So I'd like to start with saying, here's a question that you'd normally have asked. I mean, we go back to the start of that pyramid. Previously, when you had a question like, what are the rules regarding a director's liability in South Africa? You would be going to an AMLA's precedent of pleadings, or a Henochsburg, or a company's law textbook, and you would scroll back. Maybe you'd think back to your own days of being at university, some of the stuff you learned on your own experience as a legal practitioner, and you would then start doing your research, and that would take a significant amount of time. Currently, you're now able to go onto an AI model that's been trained on trusted legal content like Lexis AI, and ask and pose it this exact question, and you would get a reply. As you can imagine, this would significantly reduce costs, or reduce time rather. And so where previously you would be billing for 2 or 3 hours worth of research, you would then go now to to effectively, this might take a half an hour. But at the same time, I think your expertise, your judgment as a legal practitioner would still be as valuable as it was previously. And so as much as you are saving a lot in productivity, you are at the same time gaining a lot from, putting in your own expertise, putting in your own things in there. And apologies, it does seem the system is taking a little bit longer than I'd anticipated or hoped for this demonstration. But at the same time, even if this response took 15 minutes or 20 minutes, it would be a significant time saving according to what it was previously. I'd like us to just,
while we're
Mokone,
waiting
please.
for the system to respond, it's probably because we are on the webinar, so there's probably a lot of activity on the internet. But I think it's important to emphasize that there've been quite a number of partnerships, and we've seen big law firms take on AI-powered tools. And it's good that there are products like Lexis AI, which will assist a lot of the law firms, and big law firms like Weber Wenzel have publicly as well embraced the use of AI powered tools to improve their own efficiencies. And I don't want to influence anyone, but perhaps for the sake of the discussion, they're using Legora, which is another AI powered tool. ENS Africa as well has came out publicly informing their clients that they're also using AI-powered tools for documentation and legal research and so forth. So the likes of your Microsoft, Thomson Reuters, Lexis AI, Harvey AI, Legora, Lexis AI are certainly out there. And I think it's important that the legal profession embraces these platforms. And I mean, we've had the pleasure of seeing how these models, will certainly reduce time and efficiency. And as Claude has mentioned, I don't think the traditional method of a lawyer's input is threatened. I think it actually is enhanced.
Quite right, Mokone. I think it's all about your perspective, right? You can see anything as a threat or an opportunity. And certainly we here at LexisNexis see technology as an opportunity for our clients. We were with our clients through the entire evolution, right? We started off as a publishing house. We're still a publishing house at the moment. We're quite proud of the material that we still publish for the legal fraternity. But at the same time, we know that, we need to move forward because this technology has the ability to really enhance the productivity and the lives of our clients. And all of the firms that you've mentioned now are certainly at the cutting edge of implementing these AI products. And certainly we've already partnered with some of those firms you've mentioned as well. As here we can see, immediately you get an answer as to what the director's liability in South Africa is. And it took a little refresh from my side, as you were saying, Mokone. I think the internet on my PC is being a little bit driven up by the bandwidth of this webinar. But an important point to note here is two things. First of all, as the legal practitioner, I still have the responsibility to check the veracity of what's being given to me. As Lexis AI, we've given the client ways to immediately do this by hyperlinking to our own library. So for instance, and we'll go to case law now, but in this case, it's taking you to the exact case that puts forth the principle that we're giving you from an LLM perspective. So you can read that summary. And by the way, if you want to read the full case or summarize the full case, you can also do so on our AI platform as well. And again, this is something that previously would have taken 2 or 3 hours for somebody to summarize, or for a junior associate or article clerk to research for you, which is now happening in 5 minutes, and you're able to check the veracity immediately. Again, this is one of the ways that we aim to have our clients mitigate the risk of any hallucinations or any non-consequential arguments creeping into what they put in front of a court, is by aiding them, by giving them these hyperlinks to our trusted library to say, here's the answer, here's where we got the answer, this is how you check the answer. And it also equips you to really engage with the answer provided by the LLM. So you do get the productivity gain of getting the answer immediately, but at the same time, you're enabled as the legal practitioner to really engage with what the LLM's given you, to give your client and to give the court a value-driven output that's really based on your experience, not really just on what the LLM's given you. The same here, Nomsa mentioned earlier, where certain things would take a lot longer from a drafting perspective. I remember when I was an article clerk, we used to have a entire room full of ladies that all that they did was they drafted Section 65 notices to creditors. All right, that's a model that I think will now be automated a lot more. But at the same time, it's an additional revenue driver for those attorneys firms, because in as much as they would still need to issue these to their clients, they would now be able to automate a lot of that manual process. And really the individual, the senior associate who takes care of debt collection will just have oversight of what's being put out there, as opposed to managing a team of 20 people with human fallacies. So here we go. It's still in the process, but I'd like to direct the audience to the question that was asked. Is draft an argument on why an amendment to a particulars of claim to introduce a new cause of action will not be allowed if the new cause of action has prescribed as at the date of the putative amendment. And here it's giving us the answer. But again, important to note, it starts off with an answer and why it's giving us the answer, and then it gives us the draft to actually present in our particulars of claim. Again, something that previously would have taken 1, 2, 3 hours now takes 10 minutes to get an AI-generated reply that's based on precedent, that's based on the published materials in the LexisNexis universe, around practice areas, around rules of court, etc. And let's say it takes you another 20 minutes to actually engage with that content, read to the hyperlinked materials, make tweaks to make this your own. But again, you've reduced the time of drafting this particulars of claim from 2 to 3 hours to potentially half an hour or 20 minutes. Likewise with summarize a case. If new case law came out, again, this is an act that I'm summarizing, not a case, but let's rather put this case in here. Previously, if a new case came out or opposing counsel put a case to me that I had no history of, I would need to go on AMLA's President of Pleadings or go on our published materials in the library. I would read this case, I would read similar cases, and it would be a fairly manual process. And if you're a traditionalist like me and a bibliophile who likes to read, I sort of yearn back to that time spent in the library as a learning experience. It's a wonderful thing. And I think that's a different argument and I think that might be a very good topic for a future webinar, is to what technology and the emergence of AI and the changes in productivity will do to training in the legal industry. But certainly with regards to pure efficiency gains, it really has made a massive difference. Because again, I would get a summary immediately to this case, the material facts, the issues, the relevant legislation, the relevant case law. And again, it would hyperlink me straight to that case. So if I do want to read the entire case myself, I can do that as well. I'm just cognizant of time. Lastly, we have an upload function that actually summarizes your input. So for instance, you can upload particulars of claim from an opposing counsel, and it will provide a summary to you. And I think that's something that the audience is fairly knowledgeable of, because it is the one part of our platform that is sort of similar to another LLM. It's not trained on our internal database because, as you can imagine, it's analyzing the document provided, even though it does utilize the internal database to do so. So I'm going to stop sharing right there. I think we've all, and I think cognizant of time again, I think it's time to wrap up. But in conclusion from my side, and I think we'll go to Q&A then, and then we can wrap up. Conclusion from my side is, technology is here to stay. It's going nowhere. We had a previous webinar titled will AI replace lawyers in the future? And we had a very large number of attendees because I think it excited a lot of people, both negatively and positively. But our conclusion there was it will only replace those that don't use it. And similar to the billable hour, I think, Mokone, you touched upon it the best. I do think that gradually we'll see the working out of the billable hour as and when these productivity gains that we see from technology change the nature of the way that we work as attorneys and as advocates. But I do think it's going to be a very steady process. We'll probably start with hybrid models. We'll look at some of the models already introduced by some of our colleagues in, for instance, the audit or in the medical sphere. We'll look at some of the models already introduced in the legal fraternity, the contingency fee model. The model with regards to conveyancing, with regards to deceased estates, and I think that's how we're going to develop going forward. But certainly, it's food for thought for everybody in the room. And first of all, there will be a poll going out shortly, just before we start with the Q&A. That should come up on your screen. We'd really love everybody to take part in the poll. We're always taking data from our clients and making sure that everything is done correctly. So please do fill in the poll on your screen at the moment. But yeah, is there any questions from the audience for either me, Nomsa, or Mokone? I'm just trying to get the webinar chat up here. James Friskin asks to everyone, can Lexis AI draft heads of argument? Nomsa, do you want to take this one?
Yes, I will, Claude. It can draft a beautiful heads of argument. Look, when you've got the platform, and you'll notice once you subscribe to it, is it's not limited to, especially the last conversation tab. Unfortunately, Claude couldn't go through that, I think, for lack of time. There is a function on there, upload and summarize, where you can upload your existing founding affidavit, answering, replying, and the likes thereof. Say it's 4 documents you want to upload. And what I usually like doing on there is asking AI, summarize all of these documents, and it can do that for you. And once it's summarized, you then ask Lexis AI to draft your heads of argument under the generate a draft tab. And it'll give you the reason why, and then draft the full heads of argument for you. So you'll be able to pick up your legal issues or whatever's detailed in a heads of argument. Be able to see all of that, and then your job is then to read through it, make sure that all the facts, all the issues, all the disputes are listed in on there. Conclusion, relief, whatever the case is. Read through that, make sure that it's got a touch of your personality and character so it doesn't sound so singular. And then you paste it onto your Word document. We don't have the download option yet, but it is coming. Correct, Claude? No? Yeah.
Correct. Very shortly.
Yeah. So you'll copy paste that onto your Word document, and voila, you've got your heads of argument. So yes, the answer is yes. Lexis AI can draft a beautiful heads of argument.
100%. Thanks, Nomsa. James, I hope that answered your question. Any other questions from the audience?
You're welcome, James.
Yeah, I think maybe Nomsa, I've given my closing argument, and I think we're done with questions as well. Nomsa, maybe in closing, you can just give your opinion, Mokone yours, and then I think we can say au revoir to our entire audience.
Absolutely. Guys, I will just reiterate that growth doesn't come with gray hairs. I will say that 150 million infinity times, if there is such a number, there isn't. But it is important for us to grow with the times. AI is going absolutely nowhere. It is here to stay. So it is our job to adapt. It is our job to be and remain curious, to teach, to learn. It's not as simple as having a team app on your phone or check a 60/60. Those guys have made the platform easy by using AI. this is where AI comes in. One needs to learn what AI is, how to use AI, how to incorporate it into your organization, how it'll best fit your existing models. Maybe they even need to change, for Pete's sake, go for it. But AI is here to stay, guys. We are not going to be having the same conversation in 10 years' time. So let's get onto the train. Let's keep moving. Let's do the best out of this situation or out of this era of AI. Yeah, guys, let's keep studying, training, and stay curious. Stay curious.
Thanks, Nomsa. Perhaps before I give my closing remarks, I see there's a question from the audience. So perhaps let's afford.
Abigail, thank you so much for the question, and thanks, Mokone. Abigail, what a pain that is. I remember from when I was still in practice, you know, those things are changing, it seems, by the day. So yes, you know, to answer your question, I'll allow Nomsa to jump in as well, because she's really the fundi here. Yes, it can issue a summons to the correct MAJ court, regional court, high court citation. Yes, unfortunately, we'll still remain with the individual legal practitioner to make sure that that's 100% up to date. As much as our legal content gets vetted and updated on an almost daily basis by our content experts, you know, sometimes from experience, some of these more practical guidance parts of our system, you know, because they are changing so quickly, there is a possibility that, you know, the citation might be a little bit older. And so I would always advise the legal practitioner to just check that before submitting. But for 80% of the time, absolutely, that would be the case. Nomsa, is that correct?
Yes, that is correct, Claude. That is correct. It does provide citations. And like Claude said, it is the duty of the attorney advocate to just make sure that that citation is correct. But we do have a team constantly updating our documents on our platform.
Awesome. Abigail, I hope that answers your question. Mokone, over to you.
Thank you very much. And I think this was an interesting discussion, and I see it going forward. There's no denying that AI-infused processes will certainly help sustainability of law firms in a competitive market. And diversifying pricing, like the hybrid model that we mentioned, fixed fee subscription services, will ensure that law firms remain thought leaders in the industry by offering services that are aligned to client expectations.
Absolutely. Mokone, thank you so much. And thank you to everybody. I'd like to touch Queen's argument just before we leave, because I really like this. We find the challenge is in convincing clients on value of work and quality, especially in corporate commercial space. So itemized billing is what still works for clients, with a few accepting fixed fees. I think that's 100% correct, Queen. And I think that's something that the entire market is looking more for, is the quality of work. Like, what am I doing? And what am I getting for what I'm paying for? Not necessarily how long did it take you, but rather, what am I doing? And I think that it harks back to that previous model, pre-billable hour, where, you know, you would charge for a piece of work. You know, as I mentioned earlier, the dentist would charge me for a root canal. It wouldn't charge me for how long the root canal took me. Likewise, an attorney in the corporate space will then say to a client, well, you know, I've collected debt for you. In that instance, for instance, it very much lends itself to a model of, you know, a percentage of what I've recovered for you, which obviously has its own challenges. But when it comes to convincing the client of the value, you know, that is definitely always going to be a challenge. It's a challenge, I think, in every single industry. And that's where your persuasiveness as a legal practitioner comes in. What do you think, Mokone?
No, I mean, it's certainly true. Research shows that tech-savvy clients are more aligned to AI-infused processes that will certainly influence pricing. And I'm glad that this challenge has been raised, that there are other clients that are obviously opposed to, firstly, the use of technology and how it influences work. And earlier on, we mentioned that it remains the responsibility of clients to communicate, responsibility of lawyers to communicate with clients on how they are responsibly using technology in their processes. If your billing clearly then says that there is technology-infused processes that help you draft, but there has been input from lawyers, it certainly does speak to transparency, which ultimately speaks to the ethical considerations we've mentioned earlier. I think the more the conversations are had about which reliable AI tools are used, as we've seen in the model earlier, that clients know for sure that the information is not being compromised on open AI platforms which compromise confidentiality, and their confidence in the value of the work that is produced. Certainly, I took a while for me to get to an open AI platform slash ChatGPT, but I test driven it just so that I understand how it works. And by the time I get to more sophisticated platforms, such as Lexis AI, Legora, whatever works, then I understand how it works and which ones are safe and which ones to avoid.
Very good point there, Mokone. I think with regards to Chart's point, as well as Queen's point, I do find like the point that Chart's making there, it would have made it easier if we as attorneys had some items, as for example a dentist, that are consumables to justify the overall cost. I would challenge that, Chart, and I think having worked as a general counsel at a large corporate before, we do see actually a lot of counsels start to do that. Say, itemized billing for this sort of work. This is what I'm charging you every time. I don't think it's perfect, and I think it's a model that needs refining. But I agree with you, Chart. I think we have one disadvantage in that we don't have any consumables. But I would argue that a surgeon, for instance, is also just charging for his experience and time, and yet they have, as an industry, standardized certain things. This is what I would charge for an appendectomy, and you have medical codes that you send through to the medical aid, etc. I think it's a challenge for us as an industry, but I do think that some of our colleagues have already started adapting to this. But it's certainly interesting. I don't think we're going to walk out of this webinar with answers, but these are very, very interesting questions. And everybody on the webinar, thank you so much for joining. Thank you for your time. It was a pleasure sharing the webinar with all of you. Nomsa, Mokone, thank you so much. We look forward to seeing everybody on the next webinar. We plan on having a lot of them at the start of next year. I think as this year winds down, people are going to be more and more focused on closing the year off. And so we might not be able to squeeze one in again this year. But thank you, everybody, for your time. Certainly, I think this is a topic that was very interesting, and thank you for everything and your input as well. Have a lovely day.
Thank you.
Thank you, everyone.